Okay, good afternoon, I'm Cherry from Trademark Department. Further to John's introduction about the office action during the application, I want to introduce the trademark opposition. First of all, I'd like to introduce the table of contents to make you a primary impression. Firstly, I want to introduce the overview of trademark procedure. Next, I want to introduce the importance of trademark opposition, because maybe you want to know whether the opposition is a necessary procedure. Next, I will show the relating articles of trademark law, and at the end of this presentation, I would like to give you 2 examples to explain how we practice the trademark opposition. First of all, overview of trademark procedure. This flow chart is about the from application to registration. If everything goes smoothly, the applicant will receive his certificate of trademark in about 30 months, as introduced by John just now. This flow chart shows that if the application could not meet the requirement of the examiner, it may be preliminarily rejected by the examiner. So the applicant could file a re-examination to the trap. The time limit is 15 days, which could not be extendable. This flowchart is about the opposition. During the 3-month announcement, that is your trademarks published on the trademark gazette, and anyone could file an opposition to your mark. And if this opposition is not tenable, and your mark could be approved for registration, if the opposition could if you are not satisfied with the decision of the trademark office, you could file a re-examination also to the trap within 15 days. These 2 re-examination is 2 remedies for the interested party to protect their mark. Next one. The importance of trademark opposition. There are 3 main points I want to explain. First is the protect the priori trademark right. If one company or citizen has registered a trademark in China, or just applied for a trademark in China, and he found another party has filed a similar or identical trademark, then he could file an opposition to the trademark office against this mark. Maybe it has filed on bad faith. The second point is to apply for establishment of well-known marks. As you know, in the trademark opposition proceedings, interested party could file an opposition to a mark which he believes that it has filed on bad faith and in violation of the Article 13 of trademark law. And also, he could apply for the establishment of well-known trademark and supplement the relevant documents proving its marks well-known. I remember in 1987, the trademark office has established the Pizza Hut and its roof-shaped trademark as a well-known mark in an opposition case. And it is the first case that the CTO, namely the China Trademark Office, has established the well-known mark. As for the well-known mark, our colleague Jin-1 will give you further explanation in her presentation 1 week later. The third point is to file an opposition could act as a business strategy. Some of our clients has registered some trademarks in China in certain classes, but maybe he could not. He had not registered all the classes for application, and later when he found there is another trademark identical or similar to his mark, he may file an opposition. Since the opposition procedure may take about 3 years to receive the outcome, and during such long time he could negotiate with the owner of the cited mark to acquire the trademark or to assign this mark for his potential use. Now I would like to show the relating articles of trademark law. This is Article 30. For this article, we shall pay attention to the time limit. The person who wants to apply for an opposition, the time limit is 3 months, and this period could not be extendable. This Article 33 also has the time limits for the interested party. For the first item, if any party is dissatisfied with the decision of the trademark office, he could within 15 days to file a re-examination to the Trademark Review and Adjudication Board. And for the second item, if this party is dissatisfied with the decision of the Trademark Review and Adjudication Board, he may within 30 days to file a litigation with the People's Court. Both these 15 days and 30 days will not be extendable. If you have not filed a re-examination or litigation within this period, you may lose your right. This is Article 34. In this article, the trademark law set forth if the opposition could not be tenable, the trademark shall be registered, and the registrant could receive his certificate. And I want to draw your attention to the last item, where it is decided that an opposition is not justified and the trademark is registered. The applicant's exclusive right to use the trademark shall start from the date of expiry of the 3-month period from the publication of the accepted application. This article may sound different from other countries' practice, since in China, the registration date will be calculated from the expiry of the 3-month period, but in some countries, the registration date may be the application date.